Yeah. Okay, Dr. Ahmad, go ahead.
اوكي. مساء الخير لكل الحضور الكرام. بداية أود أن أرحب بكم ويعني ألفت انتباهكم إلى أن هذا اللقاء سيكون لغته هو اللغة الإنجليزية، وعلى من يريد أن يستمع إلى اللقاء باللغة العربية أن يضغط على الأيقونة الموجودة في شاشة الزوم على شكل الكرة الأرضية لكي يستمع إلى الزملاء الأفاضل المترجمين لهذا اللقاء، سواء المداخلات بالأسئلة يمكن أيضا أن تتم باللغة العربية وسنقوم بالترجمة. Okay, well, welcome everyone. Welcome dear colleagues and friends. Welcome to the 5th monthly meeting or seminar of the law for Palestine. I have the honor to be the moderator of this meeting. My name is Ahmad Khalifa. I'm an assistant professor of international criminal law at Ain Shams University, and I have all the pleasure to contribute to the work of the law for Palestine. In the previous meetings that we had in the last 4 months, we were concerned with the question of international law and Palestine from different perspectives, actually. We started by posing the question of what are the options and the available paths that international law present for Palestinians or for supporters of the Palestinian cause. What are the mechanisms that we can use to advance this case? What are the paths that we can walk through in order to support what we consider a just case from our perspective? We also examined in another meeting how does international law deal with certain initiatives that tries to support or to defend the Palestinian rights. And we had a meeting on BDS, and we saw how the reactions of the international law, whether in the sense of comparative law or international regional law, how did it see this tool? International law also was at the center of us exploring what are the responsibilities of the occupation in cases of pandemics. And of course, we had in mind the Israeli occupation and the situation in the Palestinian territories. And then in the last meeting, we moved from exploring what is the law to questioning or trying to evaluate how did international law contribute to the Palestinian cause and how it was used to distract the Palestinian cause and maybe rattle it in different paths that make it lose time and effort. Today, we are presenting another topic that is, I would say, we are questioning the law itself. We explored the law first in a couple of meetings and a couple of seminars, and then we tried to question whether this law served us or distracted us. And today we are stepping up another step to offer the question or to present the question of actually, is the law of occupation still valid today? Do the Geneva Conventions, as drafted 71 years ago, having in mind a certain reality of occupation, is it still good law? Is it still good law? Or maybe it's good and we have problems in implementation, and maybe there is things that are missing in this law for long-standing occupation, specifically related to the Palestinian cause, that is the most important, if not the only case of long-standing occupation in the world. So for such a topic that my friend Ihsan and myself discussed 4 months ago, we said that this is a very intriguing topic for us as scholars and very challenging topic for any listener, but to discuss it in a seminar, we need an icon to discuss it, and we didn't know So that's why we spend some time to find someone who accepts first, who is at the level of this question and who can think about the law and challenge the law and look law in the face and say that this is insufficient, this is not good law, with authority, with standing, and with due respect. This brings us to the speaker, who are very much delighted and honored to have with us today, Professor Richard Falk. I'm afraid that I may spend like 15 minutes presenting Richard Falk. I'm only telling those who are with us maybe for the first time. Richard Falk is an established academic who is teaching international law, international relations for more than 40 years in the most prestigious universities like Princeton and University of California. Robert Falk is an NGO activist who chaired the board of the Nuclear Age Peace Foundation. Robert Falk is a UN senior public servant who served as the UN Special Rapporteur for the human rights situation in Palestine. And under his mandate, one of the most interesting, challenging reports he issued, which is the report of the ISQA on the Israeli practices towards the Palestinian people and the question of apartheid. Robert Falk, in sum, is someone who stood for what he believes as right for a very long time and in different instances. He is, to sum up, he is a man of principle who is ready to pay the price for what he believes that it's right. And we are very glad, delighted, and honored to have you with us, Richard. And I am, as much as all my colleagues who are present, sure that we are very looking forward to hearing what you would like to share with us on the question of Geneva Conventions on the law of occupation, the case of Palestine as prolonged occupation. Is it still a good law? Are there ways to modify it? Is there a need to modify it? Are there ways to modify it? And if there are, how to do that? Richard, the floor is yours.
Thank you so much for that very generous and kind introduction. And I was really impressed with the kind of treatment of these important international topics that you've described as constituting the prior sessions of this initiative. And it's a challenge and a pleasure to be with you in this way tonight. And my own sense of this topic, which I think is very central to the well-being of the Palestinian people and the degree to which they have suffered from a very prolonged period of victimization in different forms. And when we talk about the Geneva Conventions, we're really addressing the question of that portion of the victimization that followed from the 1967 war and the occupation of the West Bank, Jerusalem, and Gaza. In other words, the other aspects of Palestinian victimization, such as discrimination within Israel itself, or the denial of Palestinian rights of return and repatriation, or the difficulties that confront Palestinian refugees and involuntary exiles, those are not embraced by the Geneva Convention that is applicable really to the administration of occupation. And one of the fundamental concerns is really can be expressed in two ways. One is how adequate is this Geneva framework for an occupation that has now lasted over 50 years. And remembering that a belligerent occupation by its very nature denies the people subject to it, the native population, of its normal rights and of its self-determination in the fundamental sense. So that the whole, I think, undertaking of this Fourth Geneva Convention on Belligerent Occupation presupposed that occupation was a temporary result of a war, and that it was something that would not persist. And so, having persisted this long, over 50 years, and no end in sight, points to a very fundamental question of the viability of this approach to protecting the civilian population that is subject to what has become a quasi-permanent regime of occupation that is also flawed by the fact that there's a dual system of law and administration. There's one law for the more than 600,000 Israeli settlers, and another for the Palestinian national population of the occupied Palestine. And that's why it has been increasingly evident that this is a form of apartheid that is itself a crime against humanity according to the Rome Statute governing the operations of the International Criminal Court. So one has a situation where the very nature of the occupation constitutes a crime that isn't covered by the Geneva Convention. And that fundamental crime is the crime of apartheid that is enumerated in Article 7 of the Rome Statute. And the other fundamental flaw of the Geneva Convention is the fact that I alluded to, that it was meant to be temporary. And for even the subordinated part of the population living under Israeli governance and under this double standard, one standard for the settlers, another for the Palestinians, that double standard is accentuated by the fact that Israel refuses to comply with the Geneva Convention and has successfully managed to defy some of its most fundamental provisions without suffering any kind of adverse consequences. The most that is said is that it is not helpful for a non-existent peace process, that especially the expansion of the settlements on the West Bank has sometimes been criticized, including an important resolution of the Security Council 2016, which confirmed the unlawfulness of the encroachment on Palestinian territory by the extensive settler phenomenon, which is accelerating as we speak, and which shows no sign of abatement or reversal, and makes the whole diplomacy that was supposed to end occupation and make it no longer necessary to have a framework such as provided by the Geneva Convention, that depended on the viability of the so-called two-state solution, which was never, I think, seriously intended to be implemented by Israel, and certainly in recent years has been increasingly put aside. That's a separate topic, but it bears on this to the extent that the end of occupation, as it was envisioned by the United Nations and by the United States for a long time until the Trump presidency came along, was regarded the occupation as temporary, that Israel would be required to withdraw and that there would be a Palestinian state in the occupied territories, including having a capital in East Jerusalem. So that set of expectations has been completely shattered in terms of realistic prospects for ending the occupation, ending the need for a Geneva-type framework. And it is disappointing to me that the new American president, Joe Biden, has tried to resurrect the two-state approach to ending the conflict and struggle, and presupposing the viability of a Palestinian state where no such viability exists, and Israel has made it clear over and over again, both by its behavior and also by its policies, that it will not allow the emergence of a independent, sovereign Palestine with Jerusalem as its capital. It has made that clear. So on the one hand, you have this diplomatic reassertion of the two-state solution, and then you have the existential reality that the two-state solution is not viable. So it seems like a mystification of the real problem. The real problem is how do you establish a sustainable and just peace under conditions of prolonged and oppressive occupation. And I should say something about the fact that the Geneva framework is one that does afford certain important protections to an occupied people and places significant burdens or obligations on the occupying state. And as Israel has flagrantly disregarded some of the most fundamental provisions of the Fourth Geneva Convention, and nothing beyond a light tap on its wrist has resulted. So there's, in one way, it's misleading to treat the Geneva Convention as the operative law when the realities day by day endured by the Palestinians reflect Israel's very harsh apartheid style control. So that in that sense, the Geneva Convention is a framing of the circumstances that increasingly has no real connection with how the territories are being governed by Israel. And in this sense, the reality is one of a single Israeli state that has encroached so fundamentally on the occupation as to create a situation of de facto annexation that it tried to legalize some months ago, and there was a sufficient outcry that it backed away from that attempt to create, to eliminate any ambiguity about its intentions. So what I'm really saying is that from one perspective, international humanitarian law and the Geneva Convention is obsolete in relation to the existential circumstances that the Palestinian people face under occupation. And that those existential circumstances consistently and structurally contradict fundamental provisions of the Geneva Conventions, and they would allow, if the political will existed, for criminalizing these violations of the Geneva Conventions. And I should mention in passing that the Palestinian struggle received an important victory in the domain of symbolic politics on February 5th, when the International Criminal Court decided that it was appropriate, legally appropriate, to investigate Israeli criminality after 2014 as it applied to its activities in relation to Gaza and the West Bank. And it specifically called attention in the preliminary investigation, which went on for several years, to the use of excessive force to repel the right of return demonstrations from Gaza in 2018 and 19. It also called attention to the unlawful proliferation of the settlements, and it further called attention to the use of excessive force in Operation Protective Edge in which involved Israel's massive attack on Gaza in 2014. So one has the Geneva Conventions on one side, one has the pretension of a possible peaceful, negotiated Palestinian state emerging from diplomacy on the other side, and one has a defiant Israel that doesn't want a Palestinian state and doesn't want to be constrained by the obligations of the Geneva Convention. And specifically, one can point not only to the settlements, which I've mentioned and are prohibited by Article 49, paragraph 6 of the Falk Geneva Convention in terms that command a consensus at the UN, including Western Europe and including the US until the Trump presidency, that this was, that Israel's behavior was unlawful. And therefore, if there was to be a viable Palestinian state, the settlements would have to be removed as a precondition to creating meaningful sovereignty and meaningful political independence. Ever since 2007 as well, Israel has maintained a blockade, a very harsh blockade of Gaza and its 2 million people, which is a classic and extreme instance of collective punishment, which again is prohibited by Article 33 of the Geneva Convention. So we have this very paradoxical situation where on the one side, the Geneva Conventions don't seem to correspond with a prolonged occupation that has included de facto annexation. And on the other side, you have a defiant Israel that isn't even willing to comply with the most fundamental aspects of the Geneva Convention, including several provisions which are extremely relevant to the conditions that have aggravated the situation for the Palestinians arising from the COVID pandemic. Because one thing the Geneva Convention is very clear about is the particular responsibility of the occupying power to be sure that the occupied people, and especially children, expectant mothers, and those that have any kind of disability, that they have adequate food and medical supplies. That's an imperative obligation under the Geneva Convention. And what Israel has done, and it has shocked many around the world, is to deny the Palestinians living under occupation access to vaccines while they export to foreign countries in a kind of what's been called vaccine diplomacy to countries far away like Honduras and Denmark. They export their vaccines while denying them to the protected status of Palestinians living under occupation. And I think in terms of public opinion and the impact on civil society, these infractions of international humanitarian law have really strengthened the global solidarity movement that is engaged in a variety of initiatives, including the BDS campaign, that are seeking to exert the kind of pressure that should be coming from the UN and from states around the world, including the EU. So that one of the reasons that the Geneva Convention and international humanitarian law are unable to protect the Palestinian people as the law is written is because there is an inadequate political will to do so at the international level. And this inadequate political will is reinforced by the US geopolitical muscle that shields Israel from criticism, censure, and sanctions. So that you have this situation where the Geneva Conventions are not appropriate for the situation, but even to the extent that they can be made relevant, they aren't being applied. And in a more fundamental sense, there needs to be a new additional protocol added to international humanitarian law that places term limits on belligerent occupation and sets up some alternative way of administering a territory when the occupying state has not complied with its obligations to withdraw. And that's important also because going back to 1967, when a unanimous Security Council Resolution 242 was adopted, the premise was Israeli obligation to withdraw to the 1967 Green Line borders. And that failure to do that over this half century of occupation, annexation, encroachment, a variety of wrongdoing, creates a unique situation in international political life where neither law nor morality nor political will are available to protect the Palestinian people, and their future depends on their own resistance as strengthened by global solidarity efforts. In other words, it's the people, the Palestinian people, and the people of the world that give reason to think that in some sense this ordeal of occupation, apartheid, and lawlessness can be finally overcome, but it will require struggle and perseverance that has already extended beyond what any other conflict of this magnitude has had to go through. Let me end here and welcome questions, and I hope I haven't spoken too long or in too disorganized a manner. Thank you for your patience.
Thank you very much, Richard. To the contrary, you respected perfectly the time. You even spoke for 26 minutes, so you had 4 minutes. I'm sure that we'll compensate it in questions. And your insights were very interesting to us. If I can sum them from my perspective into 3 main headlines that you navigated with us through. You pinpointed the insufficiency of Geneva Conventions on certain aspects. You highlighted the inefficiency of Geneva Conventions when it comes to certain existing rules that could be helpful, but they are not applicable for all the political panoply that you shared with us. And then you very helpfully directed us towards a concrete proposal of thinking, regardless of how practical or how doable, feasible is that the need for a third protocol, fourth protocol, maybe to Geneva Conventions now, that deals specifically with belligerent occupation, proposing substantially that this should be, that this protocol should put a time limit on the belligerent occupation and put a specific clear way of sanctions in case that this time limit does not or is not respected. So to the contrary, for me, it was very helpful. I don't want to take more than this time. I have questions, but I will keep myself till the very end. And now we will open the floor to questions. So if any of our colleagues who are present, we would like to have 2 or 3 questions, and then we'll move back to Richard, and then we'll get another round of questions. So if anyone wants to speak, I would ask you kindly to raise hand or notify me in the chat box, and I will pass the floor. Okay, Abdel Ghani, I see a hand in front of the camera. So go ahead, Abdel Ghani. There is no one else for the moment.
Yes, hi. Thank you, Professor Richards, for the talk. My question is very simple. So regarding your last suggestion, which is very very concrete, something that is not very common in topics like in talks like that one. So regarding this suggestion, just to make sure I got it correctly, so you suggested to have basically a fourth protocol to the Geneva Convention to organize the matter of prolonged occupation, to include some obligations to occupying powers refusing to simply enforce the temporality of occupation situations. How can this be backed legally, bearing in mind that I mean this will be faced by objections that this is a very political matter. The idea that the issue of withdrawing from the territory is a very political matter. It should be reached. It should be agreed upon through political arrangements. So how do you think it would be possible to defend this suggestion?
That's a really good question, important question. I would say this, that having given the occupying power more than 50 years, it shouldn't be, it shouldn't seem unreasonable to expect some kind of ending of that kind of military administration of a society. And that is reinforced by the fact that under international law, Israel has no right to acquire territory by force of arms. That the whole idea of remaining in territory that they took through military means is itself questionable under international law. And if a fair reading of Security Council 242 back in 1967 anticipated very minor border adjustments and then an Israeli withdrawal. So I'd say 2 things in response to the question. The first is that one shouldn't limit it to the Palestinian facts, that it is something that should address the generic problem of occupations that last longer than 5 years. Seems to me 5 years is a reasonable limit to make adjustments and relieve the occupied people of the burdens of occupation. And if you think about the Israeli situation in occupied Palestine, it's 10 times that reasonable time limit. And so that should seem so extreme that without directly connecting the proposal of a fourth protocol or some kind of separate lawmaking instrument, that there is a need for this kind of supplemental framework, that the Geneva Conventions just don't relate adequately to the situation where a occupation is turned into a quasi-annexation, and basically occupied Palestine is governed as part of the Israeli state, but is governed in this apartheid manner, so the Palestinian people have the worst of both worlds. They're both completely subordinated, and they have no prospect of being treated on a par with Israeli settlers or citizens. So it's a kind of double jeopardy that is imposed on them. So I think, of course, there would be tremendous opposition, but I believe that the case for putting this forward is so reasonable and so consistent with the objectives of humanitarian law that it would enjoy a lot of support in civil society, among international law experts, among those that are concerned with humanitarian dimensions of international relations, that it's worth putting forward and developing as a proposal and seeing how much political traction one can gain for it.
Thank you, Richard, for this answer. I do have a question that I would like to share or to ask you about, is to what extent you think there is a responsibility on states, individual states, to respect and enforce the respect of Geneva Conventions. This is a question tackling the efficiency part, the existing rules that we do not reach its limit of implementation related to occupation. Do you think that there is a claim under international law against states without nominating states? Let aside the US, it's a totally different story. Is there a case of responsibility versus these states that they are supporting Israel or cooperating with Israel on so many levels, especially inside the occupied territories, with so many activities that are by themselves in violation of Geneva Convention?
Yeah, it's again a very helpful question, because the Geneva Conventions themselves impose upon parties a responsibility to secure compliance. So it's itself a violation of the Geneva Convention to not only fail to implement, fail to do what is possible to secure implementation, but to be complicit with the violations is an aggravated kind of wrong. And again, this calls attention to the tragedy from a Palestinian perspective of the absence of sufficient political will to implement the law that exists. That's the fundamental problem. The problem is not so much the shortcomings of law. They do exist. There are things that could be improved, and I've tried in some way to identify a few of them. But more fundamental than the deficiencies of the law that is available is the political absence of political will and political capabilities to secure compliance with the law that does exist. And if that was done, it wouldn't be a perfect world, and occupation would still be unacceptable for this length of time, but at least it would have this extensive humanitarian protection. And if Israel failed to provide that protection, it would be subject to a variety of remedies. And I would assume that it would be subject to sanctions. And that's really the problem. The problem is this geopolitical interposition between what the law obliges and what morality prescribes and the realities confronting the Palestinian people. That geopolitical interference blocks the realization of legal, political, and moral expectations that should have long ago been realized and liberated the Palestinian people from this unendurably long ordeal. I see a couple of hands that are raised. So,
Dr. Ahmad, please unmute yourself.
Sorry. Well, actually, it was a mistake. I didn't see the place where the hands, that's why I allowed myself to ask a question before our other colleagues. So Professor, I see Lahbib Naimi, please, and then Miss Wafa, and then Dr. Sultan Habhoubi.
السلام عليكم. تسمعوني؟ شكرا شكرا مركز فلسطين قانون ولضيفكم الكريم على هذه الاستفاضة الكريمة فيما يخص موضوع الاحتلال الطويل الأمد بفلسطين. مداخلتي ستكون مقتضبة إلى حد كبير بخصوص موضوع الاحتلال الإسرائيلي للأراضي الفلسطينية. هناك أطروحة إسرائيلية وهي أطروحة قديمة إلى حد ما، لكنها متجذرة في الفكر السياسي الإسرائيلي. مفادها أن إسرائيل بعد قرار تقسيمها سنة 1948 وبعد تمدد المجال الإقليمي لإسرائيل على حساب الضفة وقطاع غزة بعد حرب 6 أيام سنة 1967 تأسست هذه الأطروحة على أساس أن الضفة الغربية وكذلك غزة والقدس الشرقية هي مناطق لا يسري عليها قانون اتفاقيات جنيف الأربع، بحيث أن إسرائيل هي حلت محل حاكم شرعي غير شرعي آنذاك له هو المملكة الأردنية الهاشمية بالضفة وكذلك الدولة المصرية بغزة، حيث كانت تمارسان كلاهما سلطة الإشراف والسيطرة على القطاع والضفة الغربية. هذه الأطروحة التي تستند على أساس أن إسرائيل هي حلت محل حاكم غير شرعي، وبالتالي فهي تتنصل من المسؤولية عن اتفاقيات جنيف الأربع. دكتور، إلى أي حد تستقيم هذه الأطروحة مع واقع القانون الدولي وكذلك الواقع العملي لمواجهة الأحداث بالضفة والقطاع والقدس الشرقية؟ وشكرا لكم.
شكرا الأخ لحبيب نعيمي. نسمع الأستاذة وفاء ثم الدكتور سلطان هبوبي. Richard, do you want to take the question immediately?
Well, I was going to say, I need your help because I unfortunately neither speak nor understand Arabic.
Yeah, sure. So the first question was about the claim of Israel that actually they are not representing an occupying authority, but they are occupying a replacement of a non-legitimate authority that occupied the territory of Gaza before 1967, which is Egypt in this claim, and which is Jordan as regards to the West Bank. So the question is, to what extent do you think that this claim has a standing in international law? So this is the first question, and if you don't mind, we'll take another 2 questions and then you answer the 3 of them together. Wafa and then Dr. Sultan.
Firstly, I would like to thank you, Dr. Richard, for this information. I have 2 questions, actually. At the beginning of this session, you discussed one of the obstacles, or let's say difficulties, that face Geneva Conventions as being temporary. I start with the term, and I would like to ask you, what do you mean by does you mean that being temporary is relating to the occupation itself or to the application of the article themselves? The second question is to, let's say that you said among that vaccine or the, let's say, policy that prevent Palestinian to get vaccine for coronavirus or pandemic. So does there any article in Geneva Convention relate to this, let's say, a field or this problem that is nowadays as the, let's say, break of the current? And thank you.
Good.
Oh, thank you very much, Wafa. Maybe Richard, you take these 3 questions coming from 2 persons, and then we go to Ihsan and Hiba afterwards.
Yes. Let me answer the last question first, because it's very raises a very concrete kind of issue. Article 56 of the Geneva Conventions specifically imposes on the occupying power the application of what they call preventive measures to combat the spread of contagious diseases and epidemics. They actually use that language, and that language, reasonably interpreted, would clearly oblige Israel to uphold its obligation to share the vaccine with the Palestinian people. It's a really unconditional obligation. And then your first question, which relates, maybe my formulation misled you a little bit. What I meant was that the Geneva Convention is suited for temporary occupation, but it is not appropriate if the occupation lasts longer than 5 years, and for more than 50 years, it's completely inappropriate. And so what I meant was that the framing of occupation was envisioned temporary presence, and not this kind of seemingly permanent or long-term, prolonged occupation, in that sense. Now, the first question, which international law people have been discussing, including myself, over many years, it seems to me to be resolved in favor of the Palestinian claims. In other words, the United Nations unanimously, and that includes the US and the EU, has treated the occupation as the occupation of Palestinian territory. And it has excluded the Israeli argument that it's really disputed territory because of the Jordanian and Egyptian prior presence in those areas. And the whole implication of admitting Palestine as a non-observer state to the UN in 2012 really resolved that issue in any serious way. I mean, you couldn't seriously maintain that position after the UN overwhelmingly voted to regard Palestine as itself a state with a certain kind of sovereignty over these territories that are now occupied. And that was confirmed in this ICC decision that I just mentioned, that the decision is very careful to say it may not be a state for all purposes, but it is a state as far as the idea of access to international institutions is concerned, and specifically the right to invoke international law on its behalf. And therefore, it clearly is entitled to be a party to the Geneva Conventions and to be protected by them. And the Palestinian Authority has made it a point to join many lawmaking treaties as part of its demonstration that it is for many purposes, not for all purposes, but for many purposes, a state that deserves to be treated as a state. And its territoriality should no longer be subject to serious challenge.
Thank you, Richard. We still have three questions. Ihsan, and then Hiba, and then Omar Mekki. Ihsan.
Okay, thank you so much, Dr. Ahmad, and thank you, Prof. Falk. So my question is, don't you agree that Geneva Conventions are focused on mechanisms of proceeding the situation under occupation, as it's a matter of jus in bello, while ending the occupation itself and the obligation in this matter is an issue of justification or reason of war or prevention of wars, which is covered by jus ad bellum. So talking realistically, what is required now is to amend the Geneva Conventions or to add a new protocol to them, as you suggested, or what is required indeed is, let's say, an intensive work within the UN to make a change in the powerful states, especially in the Security Council, to end the status of prolonged occupation, as it forms a threat to the international peace and security. So this is my first question, and in quick, the second question, I would like to know from yourself and from your experience, to what extent there is now possible to amend the Geneva Conventions, and is there like a seek within the international community, I mean, within the countries itself, for this?
Thank you, Ahsan. Hiba, you had a question? Hiba Birat, our colleague, the Executive Director, Flow for Palestine. Okay, maybe she doesn't hear us for whatever reason. Then we go to Omar Mekki, our dear colleague. Please, the floor is yours, Omar.
Yes, thank you very much, Dr. Ahmad, and of course, thank you very much to Dr. Richard, Professor Richard. It's a great honor and very interesting and enriching presentation. Perhaps my intervention is somehow similar to the recent question, the last question of our colleague Ahsan. It's basically about the amendment of the Geneva Convention, but I would go even a little bit further by just sharing a few pieces of news on the climate or the political environment nowadays, especially that we're witnessing a decreased appetite of the international community to adopt new legislation. We have witnessed recently the rejection of the proposals of the International Conference on the people deprived of the liberty in a non-international armed conflict. We've seen the failure of the resolution on the creation of a new compliance mechanism. So states are resisting any new piece of law to the already list and the package we have on the Geneva Conventions and the Hague Regulations and so on and so forth. If you add to that the persistent objection of the US and Israel, particularly as an unbreakable alliance so far since the creation of the State of Israel, and their objection to ratifying the first additional protocol, for instance, the only piece of international legislation that would grant the people that fight against alien occupations the combatant status, the resistance to the interpretation that we ICRC adopted in the Common Article 1 to the positive meaning of the word ensure respect. They are against this, and they claim that ICRC just got this interpretation out of the blue. And this not to mention the other political challenges we have, such as now the sweeping wave of normalization across the Arab region, the loss of solidarity because of other conflicts that the Arab states are kind of busy with at the current circumstances, and of course the weakness of the Palestinian authorities and structures, to the fact that we don't have until today Palestinian armed forces. Given all these different circumstances, as an experienced international lawyer who has been working in this field for 2 decades now, if not 3, would you advise us to still worry about the lawmaking, particularly on this front? Or shall we seize the opportunity now and try to engage more on the political level with new different approaches, instead of exerting more effort on amending something that is already not working in much simpler examples, such as the protracted conflicts, the international conflicts, the regular one now 10 years and 20 years in the Middle East. So these are contemporary challenges and much simpler, and we're still gonna fail to put an end to the protracted conflict. I guess I'm not sure if I was clear, but my summary of the question: shall we worry about lawmaking now, or shall we focus more on the political process and getting more states and mobilizing them to support the Palestinian cause in whatever way or form? And thank you very much. I'm sorry if I spoke for too long.
Thank you, Ahsan. Thank you, Omar. These are another batch of 3 questions coming from 2 persons. So the floor is yours, Richard.
Okay. No, these again are important questions that have been posed. Let me say that the problem raised by the first question of how we perceive how we categorize the violations of the Geneva Conventions and how we try to go about overcoming the limitations in the mechanism itself. I think that the analytic distinction that was embedded in the question is very helpful, and I think it's useful to, on the one side, talk about what the failures of compliance are, and on the other side, how can we strengthen the framework that is used to evaluate the behavior that's an issue. And I think it's a very usefully good way of talking about that distinction. The problem of a protocol or an amendment or some kind of adjustment of the Geneva Conventions, which is, I think, connects with the last group of last two questions posed also, is one that raises this question that Omar put very vividly of an international atmosphere that obstructs the establishment of effective legal mechanisms to protect the Palestinian people. And I think it was a useful distinction and a persuasive one to say that on the one side, there's a generalized reluctance to establish new lawmaking frameworks, despite the presence of unresolved problems, and to say that this reluctance is then reinforced by the vigorous opposition of Israel and the US to any kind of further development of law that is seen as putting them under some kind of additional political pressure. And one interesting, I think, observation is that even though Israel is defiant when it comes to upholding the law, they're extremely sensitive about being criticized for their unlawfulness. And their reaction, for instance, to this ICC recent decision is very illustrative of the degree to which they take law seriously, even though they're unwilling to comply with it. And what that means, and I think it's a very important point that underlies much of our discussion, is that in the domain of symbolic politics, law is very relevant to the struggle between Israel and Palestine, and that the Palestinians are winning what I call the legitimacy war, which is fought over the legal right and the legality of the grievances. And if you look at what's happened in the anti-colonial conflicts of the last 75 years, the side that wins the legitimacy war controls eventually the political outcome. Not the side that has the better weapons or the side that's stronger on the battlefield, but the side that wins, it goes against the realist politics. But if you look at how wars end in this period for control over sovereign space, it ends almost always in favor of the side that has the support of nationalist legitimacy. This should have been the lesson the US learned in the Vietnam War, where it had total military dominance and yet lost the war. See, and that hasn't been understood. And that's why these legal issues that we've been discussing are very important, even though they won't modify Israel's behavior in the short run. And that's why it seems to me extremely important to regard the audience for these kind of legal proposals and legal arguments to not be limited to governments and international institutions. The real site of struggle in these kinds of conflicts is civil society. It is the people of the world that will make the changes, not the governments and not the international institutions. And there's a kind of unfortunate sense of frustration and futility by giving all one's energy to saying, how can we persuade governments, or how do we circumvent Israeli and US opposition to making the changes that are needed to be made. What I want to express is that we can't do that, that the political reality is such that it is hitting one's head against a stone wall. But what we can do is greatly strengthen the political will of Palestinian resistance on the one side and global solidarity activism on the other side. And if you look at what brought the South African apartheid regime to an end, it was not the victory in military terms or military challenges. It was this combination of delegitimizing apartheid and developing this very robust BDS campaign that led the South African leadership to recalculate their interests. They didn't have a sudden moral awakening in the early 1990s. What they did was to realize that they'd be better off in the world by coming to terms with the Black majority population in their own country and living in a multiracial constitutional democracy than they would by imposing apartheid and becoming a pariah state in relation to the rest of the world. And I think even though the conditions are vastly different between South Africa and Israel-Palestine, there are a lot of lessons that can be learned about how that apartheid system in South Africa was brought to an end. And I think it can be very instructive for the tactics and strategy of the Palestinian movement of emancipation and liberation.
Thank you very much, Richard, for this inspiring answer. I would say nothing less than that. It could be actually the good end of the session, as it draws for us a line to walk through and to continue struggling on the legal field, even if the reality is much slower to change. But it's not the end of our session. We have still 4 questions, so I will ask my 4 colleagues to take a minute for each, and then we'll leave the floor for the last time to Richard. So it's Hiba Birat, who is back, who had a problem, and then Hassan Imran, and then Majd Musleh, and then Mona Abu Amara. If you can keep your interventions, please, to a minute. Yes.
Thank you so much, Ahmed. Professor Falk, first of all, allow me to thank you for accepting our invitation today and for the great lecture you just presented. It is well agreed that international human rights law and international humanitarian law, despite their insufficiency, should apply in their entirety to the situation in the occupied Palestinian territories. It is also agreed that adjustments through interpreting existing norms is a key here. Now, my question to you, sir, to what extent acknowledging and setting the borders to Palestinian rights to self-defense, to self-determination, to resistance would be relevant to limit the use of the state of emergency and security needs, the two arguments that are often used by Israel to derogate from the rules of the international human rights law and the international humanitarian law and to evade their application? Thank you so much.
Thank you, Hiba. Hassan, go ahead.
Thank you, Dr. Ahmed, and thank you, Professor Richard, for your very enlightening conclusion. But unfortunately, we will have to ask some technical questions before we again have another conclusion. My question is about the criterion of recognition. It's about the statehood in international law. Of course, you know about the American recognition of Golan Heights as a part of Israel. The annexation of Jerusalem as well. The criterion of recognition in international law is very political. It's not about the state itself, it's not about the legal requirements, it's not about anything that have to do with the original population. It's about what states deem proper for the situation to look like. So assuming that, let's say President Trump won another term, he managed somehow to push and to pressure the European Union to recognize the Golan Heights and Jerusalem as a part of Israel. He or whatever administration managed to create a worldwide campaign to recognize the status quo as legitimate in the Golan Heights and in East Jerusalem. Would that detract from Israel's responsibility as an occupying power according to the Geneva Conventions? That's my question.
Thank you, Hassan. Majd Mosleh.
Thank you. First of all, I would like to thank you, Professor Falk, for this intellectual lecture. I would like to ask you about the recent ICC's decision, as what you called it is a victory for the Palestinian people, and also you said that Israeli is very sensitive when it came to criticism, and they are so sensitive when it came to their laws criticism. So I want to ask you, is there any article, law, or anything that can be used by Israeli people to stop the investigation? Or in another word, how can we make this investigation continue and not to stop it in a way or another? So like what we need to expect from Israeli people. And that's it. Thank you.
Thank you, Majd. The last question from Mona Abu Umara, and then the floor is for Richard.
Thank you, Professor. As you mentioned, Israel tries to avoid being portrayed as a violator of international law, and to do so, it tries to dismiss the law itself, its applicability on itself, or its bindingness. So, in order to refute these claims, we need the law to be clear, or the resolutions, if we speak about the UN, to be clear as well. I'm especially interested in your view on the case of implementing United Nations Security Council Resolution 2334. So we know that it cannot be legally enforced by the UN since it was adopted under Chapter 7. But what, in your view, can be done in regards to the Israeli claim that this resolution is not even legally binding and it's just an opinion? Thank you so much.
Good. Well, thank you for these questions. It's a real challenge to address them all. As far as the first question from Hiba is concerned, the issue for Palestine is to not allow Israel to control the international discourse on what is legally relevant under the conditions that the Palestinians are living. In other words, to reinforce the primacy of international humanitarian law and human rights, international human rights standards, and that there is no legal justification for abandoning or regarding them as no longer applicable because the de facto situation has been established by Israeli policies on the ground that have, in a way, extinguished the capacity of to really implement these standards. It's a question, again, on the level of winning the battle for symbolic politics, which concerns who controls the discourse, who sets the parameters of how these kind of issues are to be addressed in various political and legal arenas. And the UN is one of the important, it's not important in implementing. See, and that's what many people don't grasp. It's extremely important in what I'm calling the symbolic realm of legitimacy and illegitimacy. But where it can't act because of the geopolitical blockage symbolized by the veto power given to the permanent members of the Security Council, it can't implement its decisions or its recommendations without geopolitical backing. It is, so on the level of behavior or substance, it's paralyzed. And that's been but what it's a mistake to say because of that, the UN is irrelevant or international law and human rights are irrelevant. They're not irrelevant to the struggle. They are irrelevant if you expect this intergovernmental structure to produce the results that would follow from taking the law as obligatory on a state in the situation that Israel has been in with relation to the Palestinian people. And the second question is absolutely right, that there is very vague criteria of recognition that apply to territorial claims and to issues of fundamental political rights. And you gave the illustration of the Golan Heights and whether the fact that the US government endorsed that and would now continue to do that even though Trump is no longer president, it has no legal authority. I mean, the law is fairly clear that Israel has no legal entitlement to territory of a foreign country occupied during an armed struggle. But law often gives way to geopolitics, and it's a confrontation and mobilizing resistance to that claim is really based on mobilizing public opinion, putting pressure on governments, not waiting for governments to do the right thing. And I think there's been a mistake in tactics by somehow thinking that if you make better arguments, you'll get governments to do the right thing. Governments are responding to their own perception of interests and their own willingness to pay a price for doing the right thing, and very few governments feel sufficiently motivated that they will challenge in a meaningful way. They might challenge rhetorically, but they won't challenge behaviorally these kind of geopolitical pressures. And the related question, and so from a technical point of view, there's nothing that has happened that should detract from the applicability of the Geneva Conventions to the current status of occupation. And as I've been saying, Israel has consistently violated those obligations ever since occupation began in '67, and unless it's made to suffer consequences, and what is not appreciated enough is that the only consequences it is enduring come from civil society. The BDS campaign has put more pressure on Israel than the UN has put. And to grasp that insight is to understand in a better way, a more sophisticated way, how power is deployed at this time within international relations. And that's very fundamental. And this really applies, this kind of thinking applies to the question about how can we ensure that the investigation that the ICC has said was allowable and legitimate, and the prosecutor has formally indicated that it has been initiated. How can we be sure that that won't be blocked by these antagonistic reactions of Israel supported by the US? And of course, you can't be sure. It's a political struggle. And it's a question of how strongly the independence of the ICC can be upheld under the pressure that it will undoubtedly be exposed to, including the funding pressure of who pays for its undertaking, who pays for this institution to operate. And so there's no simple answer beyond saying this is a decision that was made after very careful legal reasoning. Many groups submitted amicus briefs on both sides of the questions relating to the investigation. There is no legitimate legal objection to going forward with this investigation. The only objections will come from defiance. And in truth, the reaction, the hostile reaction, doesn't claim very much from a legal point of view. It claims that this is anti-Semitism, or it claims that it is politically motivated, or that Israel hasn't given its consent, all these kind of questions are really irrelevant given the legal process that has gone forward. And that this reasoning also applies to the question about the Security Council Resolution 2334. Of course it should be implemented. Of course sanctions should follow. But the UN is not in a position to implement its decisions if they are resisted by important P5 states. It was set up, the UN's constitutional structure is premised on the idea that its actions are unenforceable if these 5 countries don't approve. That was the whole idea. And the General Assembly is only given a recommendation authority. It has no power to decide. So it is up to people like ourselves to exert enough pressure that you change the balance of forces. There's no other way of achieving a positive outcome. And the fact that the ICC decided as it did was a victory for the notion that if this International Criminal Court was to have any credibility, it would have to treat the strong in the same way as it was treating African countries, and it would lose, it was already losing credibility. So in part, this was an institutional effort to restore confidence that this kind of mechanism could work in the world. And law isn't law if it isn't applied to all those subject to its authority. The premise of the rule of law is to treat equals equally. And if that's not done, the whole system is made to be nothing more than a creature of power, of hard power. And so my real message is, it's a political fight to make law work, but it's a fight worth having. Let me stop there and wish everyone good fortune and good being with you.
Thank you very much, Richard, for this very generous contribution and talk to the work of our organization. Every single minute, I'm sure, was a pleasure to my colleagues as much as it was for me. It was really insightful, and with such legendary people with such a wide experience like you, I'm sure that as long as the time allows us, we will find interesting stuff. And it is to be noted for our colleagues who would like to get more and more of Richard's experience, the fact that his memoirs was just published last month in February 21 in a very revealing title, Public Intellectual, The Life of a Citizen Pilgrim. It's a journey of struggle, of a lot of stances and positions that Richard enlightened us. I'm sure I didn't have the opportunity to read it, but I'm sure that it has a lot of details about all the struggles that you have went through to support what you believe is right against most dominantly big powers in this current world. I'm sure it's going to be a pleasure and to read it, and a big opportunity to benefit from everything. Thank you for all the audience, and special thanks to our interpreters, whom always have this hard task to make things available in 2 languages. We had today Noor Haqqi and Malik Diraniya. Thank you, of course, to my colleagues at Law for Palestine, Hassan Adel, Hiba Birat, Rawan Farhat. And thank you for all the audience. And most importantly, thank you, Richard, for your time. Looking forward to having you in other instances, inshallah. Good night, everyone.
Thank you for all that you said.
Thank you.